Hello guys and welcome to LawPutra's YouTube channel. Today we will discuss the most crucial aspect of family law, and that is maintenance pendente lite. I am Jagannath Kulkarni and I welcome you all to today's discussion. First of all, let us see what is maintenance. It is support or sustenance. It is not defined in marriage laws of any religious communities, whether it is Hindu, Sikh religion, or Muslim, or Parsi, or Christian. It is entitlement of claiming the maintenance, which certainly based on assumption that the claimant does not have sufficient means to support himself, him or her. Generally covers expenses for necessaries or essentials for substance of life. It is not merely right for survival of claimant. Amount of maintenance depends on number one, possession of property of both husband and wife, ability of husband to earn, then conduct of parties and other circumstances, and most importantly the parties' status and standard of life which is enjoyed by them during sustenance of marriage. Now what is pendente lite? It is a Latin term. It means pending the litigation, pending the legal suit or lawsuit. It is a temporary measure which is provided by the court to parties involved in the case, and this is to protect the rights of both the parties. It is a legal provision. It remains in effect until final resolution of case or matter to safeguard rights of all parties involved. And during the ongoing litigation process, the court may grant temporary maintenance to ensure financial well-being of affected individuals. It is a temporary relief. It establishes financial support and determines parental rights and responsibilities. It is a temporary or interim maintenance. It is granted to either spouse during the legal proceeding, typically divorce or marital dispute. This ensures that the dependent spouse, which is financially needy party, can meet its daily living expenses and maintain a reasonable standard of living throughout the legal proceedings until its final decision. And in situations involving divorce, frequently employed to assist the spouse who lacks earnings or who cannot sustain themselves throughout the legal proceeding. It is a financial support granted to either party, husband or wife, involved in dispute based on their applications. Means the claimant has to apply first to the court to get this maintenance pendente lite. This is to assist a dependent party who don't have any source of income. Usually in India, the responsibility of providing maintenance falls on the shoulders of husband, who must support his wife, parents, children, who cannot sustain themselves. And the child maintains the same standard of living as before separation. Amount of maintenance can be either monthly installment or it can be lump sum. And before awarding maintenance, what the court does, it examines the husband's financial stability and it considers the grounds on which the wife is seeking the separation. Under section 24 of Hindu Marriage Act, also under Parsi Act, husband also can claim maintenance if he can demonstrate to court that he cannot support himself or cannot maintain his standard of living due to his incapacity, physical or mental. Now, these are the statutory provisions applicable in India. The first and foremost is the section 125 of Code of Criminal Procedure. Then we have Special Marriage Act of section 36. Then we have Hindu Marriage Act for section 24. And ultimately, we also have the Parsi Marriage and Divorce Act, its section 39. These four provisions we will consider today. First is section 125. It has having all other things, and it says that it is the order for maintenance of wives, children and parents who are dependent. Other things are there, but most important let us discuss about is Magistrate may, during the pendency of proceedings regarding monthly allowance for maintenance under this subsection, order such person to make a monthly allowance for interim maintenance, and this is exactly the maintenance pendente lite to wife, children, father, mother, everybody. Also, it covers the expenses of such proceeding which the magistrate considers reasonable, and it may order the person to pay it to from time to time as magistrate will direct. Also, application for this monthly allowance, it needs to be disposed of within 60 days as far as possible from date of service of notice or application to such person. This is important. It also says this will be applicable from date of order or date of application as the case may be. It also says that in case of default, warrant may be issued. Again, in case of adultery, refuses to live with her husband and separately by mutual consent, living separately, wife cannot claim. Also, if it is found subsequently, adultery, refusal to live with, or living separately by mutual consent, magistrate shall cancel the order. So these are the basic provisions of section 125. This is the landmark case for section 125, that is Shahbanu's case, Muhammad Ahmad Khan versus Shahbanu Begum. It is All India Reporter, available in year 1985, Supreme Court, paragraph 945. Although Muslim law limits husband's liability to provide for maintenance of divorced wife to the period of iddat, it does not contemplate or countenance the situation so envisaged by section 125 of Code of Criminal Procedure. It would be incorrect and unjust to extend this above principle of Muslim law to the cases in which divorced wife is unable to maintain herself. And if divorced wife is able to maintain herself, then it is okay. Husband's liability may cease with the expiration of period of iddat. But if she is unable to maintain after period of iddat, then she is entitled to have recourse to section 125 of Code of Criminal Procedure, irrespective of the fact that she being Muslim. Now let us talk about the section 36 of Special Marriage Act. It says, it is titled as Alimony Pendente Lite, which is our today's discussion. It says, where in any proceeding under chapter 5 or chapter 6 it appears to district court that wife has no independent income. Again, Special Marriage Act talks about the wife only, sufficient for her support and necessary expenses of proceeding, it may, on application of wife, order the husband to pay to her expenses of proceeding at a weekly or monthly sum during the proceeding as the court may find reasonable. And application for payment of expenses, again the same provision, needs to be disposed of within 60 days from the date of service of notice on husband. So this is the Special Marriage Act's provision. Most importantly, section 24 of Hindu Marriage Act, and this is quite, we can say, it is the progressive act which again is talks about the maintenance pendente lite and expenses of proceedings. It clearly establishes. This is very important. It says, wherein any proceeding under this act, it appears to court that either wife or husband, as the case may be, has no independent income sufficient for her or his support and necessary expenses of proceeding, it may, on application of that required wife or husband, order the respondent, other party, to pay to petitioner expenses of proceeding and monthly sum during the proceeding, such sum as having regard to petitioner's own income and income of respondent, and the court may find it reasonable. Again the same, that within 60 days from the date of service of notice or date of application, this application needs to be disposed of either on wife or husband. This is one case, Chitralekha versus Ranjit Rai from the year 1977, which says the purpose of section 24 is to provide financial aid to indigent party so that they can maintain themselves during the pendency of litigation and not suffer due to financial crisis. So this is the utility of section 24. Another case we can say of Gulab Chand versus Sampati Devi. Again, it is from the year 1986. It says the wife applied to court for maintenance. She was granted maintenance for herself and her minor children who were living with her and dependent upon her. And the court said maintenance could be awarded to both spouse as well as children. When the children are dependent on that spouse, that wife, then the maintenance needs to be paid. Third case we can see is the Jasbir Kaur Sehgal versus District Judge. It is from the year 1997, in which what happened is wife appealed against judgment which has awarded her maintenance at the rate of rupees 1500 per month. And husband was a retired army officer, former director in ONGC, and he was accused by wife that he did not disclose his assets or an income. Then wife claimed that the father must maintain his unmarried daughter as per the Hindu Adoption Maintenance Act. And the Supreme Court verdicted that the wife has right to claim maintenance for herself and her unmarried daughter. Next case we can talk about is Savitaben Somabhai Bhatia versus State of Gujarat. It is from the year 2005. It says, Supreme Court, that if a marriage is void of bigamy, then wife is not entitled to maintenance under Hindu Marriage Act, because Hindu Marriage Act has certain provisions about the marriage. Another case we can talk about is Rani Sethi versus Sunil Sethi. It is the latest from the year 2011, in which appellant husband filed application seeking maintenance from his wife. This is something else. And husband argued that wife was running business of paying guest hotels and financially independent and stable, and husband had been thrown out of the house. His belongings were given to him the court. Couple had a 26 years old unmarried son, 24 years old unmarried daughter, and then the court verdicted that the respondent wife had to pay rupees 20,000 per month as maintenance and rupees 10,000 for litigation expenses. Additionally, also car for their use of husband and the children. Lastly, we talk about the section 39 of Parsi Marriage and Divorce Act. It says, again it is the alimony pendente lite, and it is the similar to the Hindu law. It applies to both either wife or husband, and again with the almost the same provision. Plaintiff's own income will be seen, income of dependent will be seen, and within 60 days the application needs to be disposed of. Remember, this is maintenance pendentalities. It is the crucial aspect of family law, and it provides a temporary financial support to dependent spouse during the pendency of legal proceeding, divorce, marital dispute. It aims to ensure that the dependent spouse can maintain reasonable standard of living and cover their day-to-day expenses until final decision or settlement is reached. And court determines the amount of maintenance based on the factors such as financial circumstances and needs of the parties involved. This is something classic. Alimony is like buying a hay for a dead horse. The ended marriage is the dead horse, and this is said by Groucho Marx. So thank you all. Today we discussed about the maintenance pendente lite. Thank you.